Parliamentary sovereignty. We hear this expression all the time in the UK. What on earth does it mean? Hello everyone. Parliamentary sovereignty. We hear about this all the time, at least in the UK. It's being used in the media, politicians refer to it, and lawyers do as well. In this video, I'll be giving you a brief introduction to parliamentary sovereignty and the way that that idea is understood in UK constitutional law. The doctrine of parliamentary sovereignty is well established in UK constitutional law, but make no mistake, observers in other jurisdictions and other legal systems think that, or very frequently think that, the UK is mad to have this sort of doctrine. So one of the things we need to do is unpack what's going on here, and that will provide a platform for us to think in future about whether the UK really is off its rocker. Within UK constitutional law, parliamentary sovereignty, this doctrine, this principle, refers to Parliament's ability to make law, to make legislation, acts of Parliament or statutes. And the way that this has been traditionally understood is that Parliament's lawmaking power is legally unlimited. That's the orthodox understanding of parliamentary sovereignty. In other words, on this traditional or orthodox understanding, there are no legal limits to what Parliament may enact, to the sorts of things that Parliament may legislate for. So, for instance, you get some quite gruesome examples that are discussed in the literature. Suppose that Parliament were to come along and enact legislation requiring the execution of all blue-eyed babies or anyone with red hair. The orthodox or traditional understanding of parliamentary sovereignty would hold that Parliament can indeed legislate in this way, and that if it were to do so, the judges, the courts, would uphold and enforce this legislation. So you can see already why, for some observers, this is crazy. The idea that under the UK Constitution, the legislature can enact any legislation it wishes, no matter how wicked, no matter how evil, and this will be something that the courts will give effect to, will uphold. And why? Because under the orthodox or traditional understanding of parliamentary sovereignty, no legal limits, no legal constraints as to what Parliament may legislate. The traditional or orthodox understanding of parliamentary sovereignty is often associated with a Victorian constitutional lawyer by the name of Dicey. Dicey proposed famously a formulation of this orthodox understanding of parliamentary sovereignty, and it goes like this. Dicey argues that the principle of parliamentary sovereignty means neither more nor less than this, namely, that Parliament has, under the Constitution, the right to make or unmake any law whatever. And further, that no person or body is recognised as having a right to override or set aside the legislation of Parliament. Now, Dicey wasn't making these statements just for the fun of it. He was attempting in this formulation to capture accurately what he took to be the position under the UK Constitution. This orthodox understanding of parliamentary sovereignty associated with Dicey, this notion that Parliament enjoys a legally unlimited power to legislate. There are two main implications that I just want to draw out for you. The first implication seems to be that Parliament can legislate on any subject matter. For instance, the idea that Parliament could legislate to require that all blue-eyed babies be executed. Or, for instance, Parliament could decide to enact legislation according to which anyone with red hair should be executed. These are all extreme, gruesome examples, but they are used to demonstrate that this is what Parliament is legally capable of doing Parliament has a legally unlimited power to enact legislation on any subject matter it likes, and that subject matter can be morally depraved. But nonetheless, on the orthodox understanding of parliamentary sovereignty, Parliament is entitled to enact such legislation, and the judges, the courts, will give effect to it, will uphold it. So that's the first implication of the orthodox understanding of parliamentary sovereignty. There is a second implication that I just want to draw out, and this one is a little bit less obvious. The orthodox understanding of parliamentary sovereignty suggests that each new parliament enjoys this legally unlimited power to make legislation. Each new parliament has that power, and that is in spite of any attempts that an earlier parliament may have made to constrain legally future parliaments. Suppose, for instance, that the Parliament of 1950 enacts legislation that prohibits anyone with green eyes from attending university. And moreover, in that legislation, the 1950 Parliament states explicitly that this legislation is permanent, it cannot be amended, it cannot be repealed, it cannot be done away with. It is permanent legislation on the statute book. That is an attempt by the 1950 Parliament to constrain legally future parliaments, successor parliaments. The idea is that future parliaments, successor parliaments cannot get rid of, cannot repeal, cannot legislate to remove or even to amend this legislation concerning those with green eyes being prohibited from attending university. On the orthodox or Dicey understanding of parliamentary sovereignty, none of this will work. A future parliament, a successor parliament, can do away with this earlier legislation from the 1950 Parliament in the normal way. Each new parliament enjoys this legally unlimited power to legislate, and it can free itself from any legislation that has been enacted previously and any constraints that even a previous parliament might attempt to impose. So that's the second implication of the orthodox position, the orthodox view of parliamentary sovereignty. It is concerned with the relations between statutes. The idea is that Parliament cannot bind its successors. Each new Parliament enjoys a legally unlimited power to legislate. You also sometimes see this position referred to as continuing parliamentary sovereignty. And that's in reference to the fact that on this view, each new Parliament enjoys this continuing legally unlimited power to legislate. That, in a nutshell, is the orthodox position on parliamentary sovereignty. Okay, now, much of the debate on parliamentary sovereignty within UK constitutional law has focused on this orthodox, this traditional Dicey understanding of parliamentary sovereignty. And the question has been, is that understanding of parliamentary sovereignty accurate? Is it the case that Parliament enjoys, under the UK Constitution, this legally unlimited power to legislate and the implications that we were discussing? Or, instead, is it the case that the orthodox understanding is not accurate? Is it the case that there are legal limits on Parliament's lawmaking power? And if so, what are those limits? Very roughly, there are two sorts of ways in which legal limits might emerge or might have emerged under the UK Constitution. And those two sorts of legal limits map onto the two implications that we were discussing earlier in the video. So if we turn first of all to the first implication of the orthodox view of parliamentary sovereignty, that first implication was this notion that Parliament can legislate on any subject matter it likes, including enacting legislation that is morally depraved. One suggestion here is that legal limits may indeed apply to Parliament's lawmaking power in this respect, and that Parliament cannot simply legislate on any subject matter and expect that its legislation will be recognised, upheld, enforced by the courts. There is case law, recent case law at the highest level, in which judges in their speeches have speculated that Parliament, if it were to do the unthinkable and were to legislate in some extreme way, then in those exceptional circumstances, the courts, the judges, may decide not to recognise or not to uphold, apply, enforce that supposed act of Parliament. And that suggests possibly a legal limit on Parliament's legislative authority. All of this remains speculative. We haven't had any instances of Parliament actually attempting to legislate in these sorts of extreme ways. But if we take the judges at their word in some of these cases, then it may suggest that there are legal limits on Parliament's ability to exert its legislative authority. There are legal limits potentially to what Parliament can do, what Parliament can get away with. Suppose that Parliament were fed up of the judges and decided to enact legislation entitled the Abolition of Judges Act 2020. And in this legislation, Parliament is abolishing the courts. The suggestion in some of the recent case law is that if those exceptional circumstances were to arise, the judges might decide not to recognise as valid that act of Parliament, or perhaps they might recognise it as valid, but they decide not to enforce it. There may be a number of scenarios here, but the idea is that Parliament would be facing limits concerning its ability to exert its legislative authority. And that would stand at odds with the orthodox, the traditional, the Dicey understanding of parliamentary sovereignty. Okay, so that's one area in which legal limits potentially may emerge or have emerged in relation to Parliament's lawmaking powers. The other area in which some may think that legal limits may emerge or have emerged concerns this notion that we talked about earlier about whether Parliament can bind its successors. We were thinking earlier in the video about the second implication of the orthodox understanding of parliamentary sovereignty. The second implication being that each new Parliament enjoys a legally unlimited power to legislate, meaning that if there is an attempt by an earlier Parliament, a previous Parliament, to entrench its legislation, to bind future successor parliaments, this will be, on the orthodox thinking, ineffective. It won't work. Each new Parliament is able to legislate on whatever matter it wishes and free itself from any constraints or any attempted constraints that an earlier Parliament may try to impose. So this was the second implication of the orthodox, the traditional, the Dicey understanding of parliamentary sovereignty. And it concerned the relations between statutes, the relations between earlier legislation and later legislation. Again, in this area, it has been suggested that some legal limits may potentially be emerging or capable of emerging, that an earlier Parliament may be able to impose legal limits on what later Parliaments, successor Parliaments, might be able to do legislatively. This second area of debate is really quite tricky, quite challenging. So I think it might be better just to leave this to another video. Otherwise, I'm afraid I'm going to lose my mind. Sorry to leave you on that cliffhanger, but we can return to this in another video. So hopefully this has given you a bit of an overview of this notion of parliamentary sovereignty under the UK Constitution. There is an orthodox or traditional understanding of that notion, and then there are some challenges. In all of this, it seems to be that academics are trying to develop, advance an account which accurately describes what the contemporary constitutional position is. What is the scope of Parliament's lawmaking powers? Is Parliament legally unlimited in its power to legislate, or are there legal limits? And if so, where and under what circumstances might those emerge, or have those emerged? So these are some of the issues that academics are thinking about in this area, probably thinking about too much, myself included. On that note, we should probably stop there. Thank you very much for watching, and take care.